So, let's start as usual with a very short revision of what we did last week. As you remember, last week we were talking about minors in general. We said that according to the civil code, in Japan, people become adults when they become 20 years old. And we said that minors do not have a full capacity for juristic acts. So you might remember that juristic act is a translation of the German word Rechtsgeschäft, which has been translated into Japanese as 法律行為, which has been translated into English as juristic act, which means contracts, wills, etc. So acts that have a legal meaning. We talked about torts, and we said that regarding torts, the capacity for liability, there is no concrete provision in the Japanese Civil Code, but we said that according to the president, it's around 11 to 12 years old. We talked about marriage, the trap for men. They can get married to JKs, but etc. We said that men can get married when they are 18 years old, women when they are 16, but they need to obtain the consent of their parents. And we said that regarding affiliation, ninchi, no consent is required. Why? Because it's a personal issue. It doesn't have to do with your property. It has to do with whether you want to recognize a child as being yours. So please remember that in general, in the civil code, the age issue has, in principle, 原則として in principle, to do with the protection of the property of minors. But when we go to family law issues, then we don't have to do with the protection of their property, which means that we can leave them act the way they want without consent. They are more free to do things. Adoption. When the person to be adopted is under 15 years of age, we need the consent of his parents, which means that if the person to be adopted is 15 years or more, no consent is required. He or she can say, yes, I would like to be adopted by them. However, please remember, in cases of adoptions of minors, in principle, 原則として, we need a permission of the family court, and you can easily guess why, to avoid some bad situations, etc. Will, 15 years old. Again, why? Well, there is no need for protection of his or her property. It's a family law issue, and he is going to leave his property or her property after the death. So it's a personal issue, 15 years old. Then we moved to the penal code, Keiho. We said that according to the penal code, crimes committed by persons less than 14 years of age are not punishable, which does not mean that they are free to do whatever they want. We have the Juvenile Act, Shonenho, which provides for a different procedure, but it doesn't have to do with punishment. It has to do with re-education, etc. And we said that according to the Juvenile Act, persons under 18 years of age, if they are supposed to be sentenced with a death penalty, it becomes a life imprisonment, etc. So you can see the difference in the punishments too. Smoking, drinking alcohol, labor. Some of you asked me, Professor, I'm working, I'm doing a part-time job, and they didn't ask for the consent of my parents. Is that okay? The answer is yes and no. Why? Doing a part-time job is a contract. It's a labor contract between you and your employer, which means that it's a juristic act, which means that if you're not 20 years old, you need to obtain the consent of your parents. But you didn't, and you're working. Is that illegal? No. Because, as you can see here, juristic acts, contracts, in contravention of this may be rescinded. 取り消すことはできる。Which means that if you go back to your house and your parents ask you, what are you doing? Oh, I'm doing a part-time job. You didn't ask for our consent. Yes, I'm earning 5,000 yen per hour. Congratulations. That's all. You or your parents are not going to rescind the contract, so it's okay. So you can see that the minor and his parents can choose whether they are going to rescind the contract or not. Okay, it's not mandatory, it's not an obligation. Now, okay, smoking and drinking is easy, but please remember that there is a minimum age requirement, which is quite complex as you remember. You can see it here. And voting, 18 years old. That's all with the revision. Any questions? Yes, Matthew? Oh, the microphone. Could you please pass it? So you also need to remember your names, okay, each other. So here's Matthew. Okay.
Sorry, just one hypothetical with the recognition of children. In cases where there's been an affair and a child is born, if the man doesn't recognize the child, then he doesn't have to pay support, potentially.
Thank you very much, Matthew. So, your question brings us to today's material. So, could you please all check today's material? By the way, Matthew is a student of the Faculty of Law, and he asks excellent questions. Excellent questions. Each time he asks me something, I'm like, wow. So, let's move to today's material. Yes, so, before answering your question, Matthew, this is a photo taken by me. Clap, 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 thank you. Then, I took it while I was on the bus coming to Kyoto University today at 11 o'clock. They were having the Aoi festival. I didn't know anything about it, so I was kind of surprised. I was looking out and I saw this. It was like time travel or something. So, today is a festival day, but you are here and you're attending the lecture about law and culture. Congratulations. So, let's move to, it's one of the, I think, 3 big festivals in Kyoto. 3. Aoi Festival, the one in August. Yes, Gion Festival.
The only one anyone ever knows.
Yes, I forgot the name anyway. And there's also, I think, another one. But this one is quite good. It's the first time that I saw it. If you take bus number 3 at 11 something, you will pass by the festival. You don't have to go out and stand under the heat, okay? So it's number 3, please remember. Okay, which comes also to Hyakuman. So you can use that. So, Matthew, again, before answering your question, this is a revision slide. please be careful when using it, because as you can see, it has only the important, the basic information. And regarding affiliation, 3 students asked me a question about the affiliation, so I was going to talk about it anyway because it's quite interesting. So, who would like to read Article 779 of the Civil Code? Yes, please, Ojisaki.
A father or a mother may affiliate his or her child out of wedlock.
Thank you. So, according to this provision, a father or a mother may affiliate, but as you can easily understand, in principle, the mother does not need to affiliate because she gives birth. So we know that she is a mother. Of course, there are exceptions, surrogate, etc. But in principle, the woman who gives birth is the mother, so she does not need to affiliate. So it's the father who affiliates. The question is, what happens? So, if you have a look at Article 780, so it's the next article, you can see that, as we said last week, even minors can affiliate without consent. And now we go to the answer for the question, for your question, Matthew. So, what are the effects, the results, if there is an affiliation? First, the child can take the surname of the father. You can see that it's a can, so it's not an obligation. Depends, okay? Second, the father can exercise parental authority if both parents agree. So again, it's a can, it's not a must. Number 3, so Matthew, this is the answer. The child has the right to ask for support against the father. So, the answer is yes, if there is no affiliation, then the child is not officially, which means legally, a child of that person, which means that the child has no right to ask for support. Yes? Oh, could you use the mic? Oh, sorry, the mic.
My question is more that if the father doesn't recognize him, then he doesn't have to pay. Are there processes like compulsory DNA testing, for example?
Thank you, excellent question. Yes, there is a different procedure, so the child can ask, has a right to ask for that, but we are not going to talk about details today. If you attend my lecture during the second semester, the fall semester, we are going to talk about that issue. Or you can come and ask for details. Okay, thank you. So, but yes, there is a procedure. The child can ask, because usually, not usually, but there are many cases where the father does not affiliate, so yes, there is a procedure. Yes. However, the DNA test is not compulsory, but we're going to talk about that later. And finally, the child becomes an heir of the father, which means that, again, if there is no affiliation, the child has no inheritance rights. So I would say that maybe these last 2 items are the most important from the child's point of view. Okay? Any other questions regarding this? And today we are going to talk about elderly people. So it's completely the opposite from last week's lecture. We will start by saying that, surprisingly, in 2013, people who were 65 years old and over were 25% of the total population. Which means that if we have 4 people in Japan, well, 4 years ago, one of them would be 65 years old or more. And according to some estimations, in 2035, the percentage will rise to 33.4%, which means that 1 out of 3 will be 65 years old or more. So the first issue is that, well, you know about that. There is a big demographic issue in Japan because the birth rate is falling and the life expectancy is even longer and longer. From another point of view, this is a business opportunity. Businesses that have to do with elderly people will bloom in the future. And I went to Vietnam this February, and I was talking with a lawyer from a big law firm, a Japanese law firm, who has an office also in Vietnam, in Ho Chi Minh. And he was telling me that many Japanese companies are going to Vietnam because Vietnam will have the same issue in a few years. So, as you know, Japanese companies have a big experience regarding the care of elderly people, and now they're going to Vietnam to do the same business because the Vietnamese companies don't have so much experience. So you can see that it's an issue globally, not only in Japan. Well, another factor is that, as you can see, we men, we don't live so long. Women live longer, a lot longer. So, if you see it from this point of view, maybe men should get married with women who are older so that they can actually live together. Because if there is a big age difference, they're not going to live together so long. But anyway, that's a maybe, so you have to think about that. Another issue is that time is money. We are all going to die one day. And when I say this, some people say, "Engi demonai," oh, don't say such things, it's not good, etc. But it's our fate. We are all going to die one day. I have a friend who says, birthdays are not something to celebrate. We are approaching one step towards our death, so we shouldn't be celebrating. But I think it's better to celebrate, celebrate that because getting older has also some good aspects. You become wiser, you have more experience, etc. So it's not only approaching to your death. So, while you are and we are and I am still alive, we should watch a lot of movies. Why is that? Because movies teach us a lot of things. For example, this movie In Time. In Japanese, I think it was translated Taimu. Amanda Seyfried and Justin Timberlake. An excellent movie which shows us a future society where time is actually money. Or we could say time is your life. So, in this society, people have a clock on their arm which shows the remaining time of their life. And they don't pay, they don't use money, they use their time to buy things. It's quite interesting. So, if you are a millionaire in this society, in that society you would have many years of life, 100, 200, 300, maybe 1,000 years. And you could use your time to buy a house, to buy a car, etc. And as you can easily guess, poor people cannot buy even their food because they would have only 2 hours, 3 hours, maybe one day. So they would need to do something to keep themselves alive. It's quite interesting. I think you should watch it. After watching it, I think that you're not going to sleep during the lectures. It's a waste of time. So you would say, no, I'm not going to waste my time. So anyway, I strongly recommend you to watch this movie before the final exams. So, time is money, which means that I'm actually using your time now, and you're using my time. We are mutually using our times, which means that if the lecture is not interesting, then I'm wasting your time, which means that I'm wasting your life. And when you're going to make presentations in a lecture, please try not to waste the times of the others, because sometimes students make a presentation which is not interesting, and I tell them, you know, it's okay, but you're wasting the other students' time. You're wasting their lives. So that's why you should prepare well when you are assigned presentation. Now, seen from a different point of view, if the lecture is not interesting, don't sleep, you're wasting your time. You should make it useful. For example, let's say it's a lecture in Japanese, the professor speaks very fast and you don't understand anything. You will say, this is not a lecture, this is a listening examination. I'm gonna write down each and every word he says. So it would be a practice for you to take notes. So it depends on you. It depends on how you react to the lecture or any presentation, etc. Question. So the question is, do we have certain age limits like we did when we were talking about minors? Answer, no. In general, as you also saw on this slide, elderly people are people who are 65 years old and over. Why is that? Because in Japan, the pension, nenkin, the pension eligibility, the age limit is 65 years old. So you can actually start receiving the pension when you become 65 years old. It's not the same with the retirement age. Please be careful. For example, in public universities, like Kyoto University, we professors have to retire when we reach 65 years. But in most private universities, for example, Kansai University, Waseda University, etc., it's 70 years old. So, what happens is that many professors retire from the public university when they become 65, and then they go to teach at private universities so that they can get more salaries, pensions, etc. So, the first issue is that there is no official age for elderly people, but in general we use 65 years because it's the age when you can start receiving your pension. However, if you have a look at the Road Traffic Act, so please have a look at the Road Traffic Act, page 1 of the provisions. I am not going to ask you to read this provision, but you can see that in number 1, so in paragraph 1, number 1, it says holders of a license who are at least 70 years of age. So these persons are called elderly drivers. In Japanese, kore untensha nado, according to this act. Because it has a different purpose, okay? It needs to protect the safety of the people, etc. And in some other acts, we can see a division between early elderly people and late elderly people. So for students who are good at both English and Japanese, like you, please consider a better translation. In Japanese, this is Zenki Koreisha and Koki Koreisha, like Zenki and Koki for your semesters. So there are many translations which are not satisfying. I think that maybe this is the best one. There's no official translation. But I think that early elderly and late elderly is quite a good translation. If you can think of a better translation, please tell me. So, the next question is, okay, you told us that we are all going to die, yes. You told us that time is money, yes. You told us that I can waste your time, you can waste my time, so we're not going to do that, yes. Or at least we'll try not to do that. You told us that there is no certain age for elderly people, but we usually use 65 years. Next question. Why are we talking about elderly people? So we talked about minors because they don't have full capacity to act, etc. So what's common? That's a question for you. What's common between minors and elderly people? 共通事項. What's common between minors? What do they have in common? Yes, could you please pass the microphone? Could I have your name again? I'm sorry, I should remember. Okay, yes, sorry. Yes, he's coming.
I think they are both vulnerable.
Excellent, thank you very much. Thank you, great answer. They are both vulnerable. Who would like to translate vulnerable into Japanese? Yes, please. So could I have your name?
ユースケ・マスダ。
So Yusuke, how would you translate vulnerable into Japanese?
弱者とか弱いとか。
Excellent, thank you very much. So, why did I ask this question? My specialty, so my field of research is mostly consumer protection, consumer law. And in consumer law, 消費者法, we have the issue of vulnerable consumers. And we are discussing about how to translate that into Japanese, vulnerable consumers. Some professors say it's 弱い消費者. Other professors say it's 脆弱な消費者, 脆弱な消費者. Other professors say no, it's 保護を要する消費者. So you can see that a word which seems to be easy is sometimes difficult to translate. But Yusuke, you're right, yes. The main meaning is 弱い or 脆弱な, etc. So both minors and elderly people are vulnerable, 脆弱, 弱い, etc. And again, as you know, I have learned a lot of things from movies. So I learned about that thing from this movie, The Curious Case of Benjamin Button. In Japanese, Benjamin Button no Suki na Jinsei, which I'm not sure if it's a good translation anyway. So Benjamin Button, Brad Pitt and Kate Blanchett. So he was born, as you know, as an old person. And as he grows older, he becomes younger. He also has a love affair, which is nice. I like love affairs. I love this scene. It's the scene which shows how excellent, how nice it is to be young. You know, there are some things you can do only when you're young. If you see the movie, you will understand. So yes, you can do most things during your whole life, but there are some things which are not so nice if you do them when you get old. So you should do them at least once when you're young. For example, like this scene. And then as he grows older, he becomes a baby. So he needs to be looked after again. So he needs to be taken care of at the beginning and at the end of his life. So this is actually what happens. We are born, we need a support because we cannot walk. We walk slowly, we eat slowly, we talk slowly, and before dying, again it's the same thing. We walk slowly, we eat slowly, we talk slowly. So you can see that it's a circle actually. So I would say that life is not a straight line. Maybe it's a circle. You start, you reach the maximum, and then you go back, and it's a full circle. So, before the final exams, okay? Or after the final exams, anyway. So it's a movie that I need to read the book. There's a book, as you know. I need to read it because I like the movie so much. So I need to read the book. So please tell me, don't forget to tell me during the 15th lecture, you are going to read this book during the summer vacations. Okay, please tell me that. I'm gonna forget about this book. You can do this after your final exams, but not inside the campus, okay? So, when we are young and when we are old, we need support. Support is a difficult word to translate. It could be shiji, it could be shien. In this case, it's a legal term. It's a legal term, which in Japanese is translated as fuyo. So, what's the meaning of this fuyo? Let's start with Article 820 of the Civil Code. Who would like to read the article? Yes. Could I have your name again? Sorry. Maho. Yes. Sorry. Oh yes, Maho Akui. Yes. Oh, you need the microphone. Yes, of course. So Maho, you're Maho, he's Yusuke, you're Yusuke, she's Maho. Okay, you need to remember the names. It's easy for me to. So Maho, could you start with Article 820, please? Oh, there's no 120? No. Oh, I'm sorry. Yes, I will add it again later. So, Maho, do you have an internet connection? Okay. Japanese law translation. And if you have mobiles or PCs, you Google Japanese law translation. You find the page of the Ministry of Justice. And you go to search by title. You put Civil Code, and did you find the article?
Is it?
It's the second part, not the first part. I think it's divided in two parts because there are many provisions. It's in parts 4 and 5. So if somebody has found it, please raise your hand. No? Yeah. 820, is it? Yeah. So please, could you read the article slowly?
A person who exercises parental authority holds the right and bears the duty to care for and educate the child for the child's interests.
So,
Is
yes. Once again, please, slowly. Once again, because they don't have the text.
a person who exercises parental authority holds the right and bears the duty to care for and educate the child for the child's interests.
Thank you very much. So, as you can see, there is a right and a duty of the person exercising parental authority to care for the child. So, why did I start with this? This has to do with children. So if you are a child, if you are a minor, there is somebody, the person having parental authority, who has the right and the duty, it's also a duty, to care for you as a minor. The next question is, yes, but who is that person? If you have a look at Article 818, page 5 of the provisions, 818, you will see that a child who has not... Okay, so Maho, could you also read Article 818? You have it in your provisions, page 5.
A child who has not attained the age of majority shall be subject to the parental authority of his or her parents.
And also, please, yes. So, if you are a minor, you are subject to the parental authority of your parents. And some students ask me, what happens if there are no parents? Then you go to Article 838. So Maho, please, 838.
Guardianship shall commence in the following cases. I, if there is no person with parental authority over a minor, or if a person with parental authority is unable to exercise the right of administration of property. I, if there has been an order for commencement of guardianship.
So, if there is a minor, the person who has parental authority, in Japanese, shinken, has the right and the duty to take care. Who's that person? Article 818. In cases of minor, it's his or her parents. Question, what if there are no parents? Article 838, the guardian. I know that guardian sounds a bit like a Disney movie, but in this case it's kokennin. Okay? So it's either the parents or the guardian. So, according to this provision, there is a right and a duty for people having parental authority to take care of a child. But it's not about elderly. So, next, we go to Article 877, paragraph 1. Who would like to read this provision? Yes, maybe?
Lineal relatives by blood and siblings have a duty to support each other. If special circumstances exist, the family court may also impose a duty of support between relatives within the third degree in addition to the case prescribed in the preceding paragraph. If an alteration in circumstances arises after an order pursuant to the provision of the preceding paragraph, the family court may revoke that order.
Thank you. So, according to this provision, there is a duty to support each other regarding lineal relatives, so by blood and siblings. So the question is, who are the lineal relatives? They are blood relatives in the direct line. This is quite interesting. I found it on internet. I think it comes from Encyclopedia Britannica 2008. It's interesting because me, so the person to whom we will refer to, is ego, which in Greek, in my language, ego means me. So egoist is the person who thinks only about me, about himself. It doesn't mean that we Greek people are all egoists. But ego in Greek means me. Okay? So, you have Mr. Ego, and the question is, who are his lineal relatives? The answer is the people in blue. Why is that? Because they are connected with a straight line of births. So it's his children, his parents, and his grandparents, and also, yes, so that's all. So, how about the other people? They are collateral relatives. Why? Because they share the same blood. For example, his siblings, brothers and sisters, they share the same blood with him, but they are not connected in a straight line, so they are not lineal blood relatives. So according to the provision Lily just read, lineal relatives by blood and siblings have a duty to support each other. So we are like, yes, we found it. We found a provision which says that also children have to take care of their parents and their grandparents. They have a duty to support. But, Lily, 878.
In the case where there exist several persons under a duty to give support, an agreement has not or cannot be reached between the parties with respect to the order in which they are to give support. The family court shall determine the order. In the case where there exist several persons entitled to support and the financial capacity of the person under duties to give support is insufficient to support them all, the same shall apply.
So, as you understood, Lily, this provision has to do with cases where plural persons bear this duty. So there are, let's say, 5 children, and the father has Alzheimer, he is old. So they need to decide who will take care, etc. But if you have a look at the second half of this provision, it says that the financial capacity of the person under a duty to give support is insufficient, etc. So, according to university professors, according to scholars, this means that in order to bear this duty, you also need to have the capacity to do so. Which means that if you don't have money, if you're not working, for example, if you have no income, etc., then you don't have the capacity to take care of that old elder person. So, as you can see, it's a duty, but it's not a strict duty. You need to have the capacity to do so. Second issue, Lily, Article 879. And you have reached the maximum for today. Congratulations.
If agreement has not or cannot be reached between the parties with respect to the extent and form of support, the family court shall determine such matters, considering the needs of the person entitled to support, the financial capacity of the person under duty to give support, and any other related circumstances.
So, Lily, we said that yes, there is a duty, but it's not a strict duty. There also needs to be a capacity. So if the father is an elderly person, the children bear the duty, have the duty to take care, but only if they have the capacity to do so. Second issue, do they have the duty to take care? This is quite difficult to translate into English. In Japanese, it's hikitori fuyo, which means actually receiving your father in your house and personally taking care. So now we will talk about what the content of this care is. There is no provision. But according to this provision, which Lily just read, 879, you can see that it says about financial capacity, etc. So many university professors, many scholars say that no, there is no duty to personally take care. It's just a duty to financially take care. Another reason for this is that you don't have this slide. Meiji Civil Code. What's that? It's a civil code that the 3 young Japanese professors prepared, if you remember. At first we had a French guy, but etc., and we had 3 Japanese professors. It's called Meiji Civil Code because it has been reformed sometimes, etc., so it's not the same now. It's the same civil code, but with a different content. So we call this the Meiji Civil Code. There was a provision regarding the order of support. We'll talk about this later. And, okay, let's have a break, 5 minutes break, and we will continue after that. If you have any questions, feel free to ask me. Thank you. So, your questions were excellent as always. I will just add some information regarding Chisaki's question, who has reached the maximum for a fourth consecutive week. Congratulations. Her question was, okay, so you said that you said that there is a duty to support, and then you say that there is no duty to take care. What's that? Is that a mistake? Is it a different thing? Is it the same thing, etc.? The answer is, please be careful. These two are different things. The first is a duty to support, which means, according to the provisions, to financially support. So if there is a father, a mother who don't have the financial means and they are elderly people, yes, you have the duty to financially support them. Why is that? Because you are lineal relatives by blood. The same goes with brothers and sisters, siblings, so please be careful. It's not that maybe you have a brother or a sister. You cannot say, no, I don't care about him, about what he does or she does, because according to the law, you still have the same duty to support financially. Now, another issue is the duty to take care, not to support. The duty to take care means the duty to actually take care, to give them a bath, maybe feed them, etc. So, we stop here. we're talking about this issue. Is there a duty to personally take care? You can do that even if you don't have money. Okay, you can live together, bathe them, etc. Now, we were talking about the Meiji Civil Code. As I told you, it's the same civil code with the one we are currently talking about, but in a different version, so before some reforms. Please be careful. Under the Meiji Civil Code, yes, there was a provision saying that in such cases, for example, in cases of lineal or blood relatives and siblings, there is a duty to personally take care. Hikitori fuyo in Japanese. This was deleted, sakujo, and as you can understand, there was strong resistance because people were saying, no, you're changing the structure of the Japanese family if you say that there is no such duty. So that's why they added this provision, which you don't have in your material, which says mutual help between relatives. And it says that lineal relatives by blood and relatives who live together shall help one another. Question: what does that mean? Answer: nothing. They just put it so as to give a reason to people who were saying, no, don't delete this provision, we need to have this provision. They needed to give them something new. So they said, okay, we will delete this provision, but we will have this. So there is still something. You see that it doesn't say duty, it doesn't say something like that. It says nakereba naranai shall, so it's just a shall. But it was good enough for them. They said, okay, we have this, so yes. So, what has changed in the Japanese family? Before that, there was a provision stipulating for the option of taking care, which means that if a father or a mother grew old, and if he or she, for example, had Alzheimer, the children had an official duty to personally take care, which was deleted. And also, under the Meiji Civil Code, regarding support, so financial support, there was an order if there were plural persons having the right. What does that mean? Let's say that you get married, your parents have Alzheimer, they cannot work, so you need to financially support them. Your children, they are also not working, so you need to financially support them. And your wife or husband is also not working, so you have many people around you who you need to support. Under the Meiji Civil Code, there was an order. Number one were the parents, lineal ascendants. Why is that? Because in Japan in the past, the father and the mother were the center of the family. In Japanese it's called ie seido, for example. So they were the head of the family, which means that, of course, they would be given priority. Number two were the children, and you can see that the husband and the wife were number three, so marriage was not so important. The father or the mother were most important, then the children, and the spouses were the last thing. This provision was also deleted during the reform in 1947, after World War II. So you can guess why, etc. Okay, we have talked about this issue when we were talking about the Constitution, so maybe it's something the same. So, what do we have today? Today we have Article 760. You don't have it in your material, but you can check it later, which provides for a duty of spouses to share living expenses. In Japanese, it's called kon-in-hyo no buntan. Living expenses is kon-in-hyo. Kon-in is the marriage. So kon-in-hyo. And lawyers call it konpi. Kon-in-hyo, konpi, no buntan. So, under the current civil code, spouses are number 1. Why is that? Because it's an official duty. You need to share the living expenses. So, if your husband or your wife is not working, you still have to share the expenses, you still have to pay for his expenses, etc. And this is a provision which we use in cases of couples, husband and wife, who are not living together. The husband finds a young woman, he moves away, and he leaves his wife. Question, does he have to pay money to his wife? Answer, of course, because he has the duty to share the living expenses. So you can see that under the current civil code, spouses are number 1, the husband and the wife. And parents are maybe number 3, we could say, because children are number 1 or 2. There is an official duty of the parents to take care. But in cases of parents, it's just duty to financially support. Only if you have money, and no duty to personally take care. So, a question I received by some students was, wow, that's so cruel. So if you don't have money, then you don't have to give money to your parents. You don't have to personally take care of them. So what is going to happen with them? Answer, there is another system, a state system, a public system for taking care of such cases, which will not be discussed here today. Any questions? This is the public library in Athens. This is the building of the Academy of Athens. And this is the building of Athens University. But we were not having lectures here. We were only having the ceremonies. The lectures were held in an old and very dirty building. So I only entered this building twice as a student. And you can see that somebody has written something here using paint, but it's okay, it's still beautiful. Anyway. So if you go to Athens, these 3 buildings are on the same street in a row. So I think you should visit them, take a photo there. I strongly recommend that you will have something like a sheet on your white sheet and maybe something like an olive branch so that you will look like a god, insect god or something. But it depends on your what you prefer, so yeah, you're free to choose. So, now we move to the next step. Let's summarize a bit. So, under the Japanese civil code, there is a duty of parents to take care of their children. Yes, it's official. It's also a right, okay, and a duty. How about the other way around? Well, no. It's a duty only to support, which means financial support, so you need to have money. You don't have the duty to personally take care. It's a bit unclear, but as you saw, they deleted that provision. So we could say that yes, they deleted it because they wanted to change the structure of the Japanese family. So in the past, it was parents, children, husband and wife. Now we could say it is husband and wife and children, maybe the same, and then parents with protection. So we leave that thing to the government, to the state. Next issue. Yes, but let's say that you live together. Okay? You live together, you have money, and you're taking care, also personal care. So you don't care. You're rich, you have the time to do everything, you're doing it. There's another issue. Your father or mother, let's say, is 90 years old and has Alzheimer's. So he or she starts going out, going to music stores, and buying 100 Michael Jackson CDs every day. He or she buys the CDs, and he's like, oh, I love Michael Jackson, then puts the CDs away, and next day he or she wakes up and says, oh, I need to buy Michael Jackson CDs. So he or she goes and buys them again. And next day he or she goes and buys them again. So you say, ooh, that's dangerous. We need to do something about that. How could we stop that? Guardianship. As you remember, in cases of minors, the same thing can happen. In the future, you might get married, and if you have children, maybe your child will say, I love Pokemon, so I'm gonna buy 100 Pokemon books every day. You need to stop that. Oh, you can stop that in Japan because he or she needs to have the consent, etc. So, in principle, you can rescind torikesu and say, give me the money back and take your books back. So, what happens in cases of elderly people? 3 systems: adult guardianship, curatorship, and assistance. For Japanese students, you need to be careful of the kanjis. Hosa and hojo have almost the same sound, but the kanji is different. And adult guardianship, both for international and Japanese students. We have adult guardianship. Why is that? Because we also have minor guardianship. What's that? It was article, the one that Lily read. Which one was that, Lily? Okay. Yeah, 838, which Lily read. So as you remember, in number 1, it says that guardianship also starts if there is no person with parental authority over a minor. So, if there is a person who is 16 years old and no parents, a guardian will be assigned. He will be a miseinen, that system will be a miseinen koken, a minor guardianship. And if a person is 20 years or more, but his mental status does not allow him to do things by himself, we will have the adult guardianship. Please be careful. 2 systems, for minors and for adults. And we also have curatorship and assistance. So, let's start with guardianship. You don't have this slide. It has to do again with the civil code before the small reforms. So under the civil code before the reforms, there was a system for incompetency and quasi-incompetency. And if you also read the Japanese letters, you can understand that the name is not so pleasant because people will say he is incompetent or he is quasi-incompetent, which is not so pleasant. So that's why they changed the name during this reform. Another thing, they used to have 2 systems, which means that they would only cover heavy cases and middle cases, but not the light ones, not the ones where there is a mental issue but it's not so heavy. That would not be provided for. But nowadays, we have 3 systems. So you can understand that this is the most heavy, This is the middle and this is for light cases. So let's see the details. Who would like to read Article 9 of the Civil Code? Yes, please. Could you pass the microphone again? So what's your name?
Masato Kisada.
Okay, thank you. So Masato, yes, could you read the Article 9?
Article 9. A juristic act performed by an adult work may be resigned. Provide, however, that this shall not apply to any act relating to daily life, such as the purchase of daily household items.
Thank you. So, you can see that in cases of an adult ward under guardianship, all juristic acts performed by him or her can be rescinded. Please be careful. It doesn't say anything about consent. No. So everything he or she does, which has a legal meaning, can be rescinded. Question: why is it a can? It's the same with minors. Let's say that your father or my father has Alzheimer. He goes to a store and he sells this watch for 1 million yen. Bravo, bravo, father. How did you do that? Of course, I'm not going to rescind because this is only 20,000, okay? So it's a bravo and excellent, so we're not going to rescind. So you can choose. You will see what he or she has done. And if you think you should rescind, then you rescind. Exception: purchase of daily household items, etc., of course. Because otherwise, they could not go to supermarkets and buy things, etc. So these things are an exception. Yeah, so Masato, could you also read Article 120, paragraph 1, please?
Article 120. An act which may be resigned on the grounds of the limited capacity to act, or the person who performed such act may be resigned only by the person whose capacity to act is limited, or its agent, successor, or person who has the authority to give consent.
Thank you very much. This article, please be careful. We use it for minors and all three categories that we're talking about today. Last week, some of you asked me, let's say that I'm a minor. I go to a store, I buy Pokemon books, 100. So my father tells me, no, I didn't consent, so I'm gonna rescind. And let's say that the minor says, no, I'm gonna keep the books, you're not going to do that. Can he or she still rescind? Answer: you have a look at Article 120. It says that the right to rescind belongs to the person who performed the act, whose capacity to act is limited, or its agent. For example, the statutory agent, the father and the mother. And it's an or, which means that, yes, they separately have that right. Even if the son, the child says no, the parent can rescind. The same here too. Next, we also have a curatorship and an assistance system. So, the question here is, what's the difference between the guardianship, the curatorship, etc.? So, let's start with the curatorship. Who would like to read Article 11? Yes, please. So, Yosuke, Article 11, please. Page 2.
So, Article 11 is respect to any person who whose capacity is extremely insufficient.
Thank you. You underline extremely insufficient. So Maho, while he will be reading the next article, you will look for the article which says commencement of guardianship. It's Article 7, I think. So you will have a look. Next, Article 15. Yosuke. Page 3.
So, Article 15. With respect to any person who has insufficient capacity to
Thank you. So you underline insufficient capacity. So please add here that in cases of assistance we have insufficient capacity. In Japanese, 不十分。能力が不十分。In cases of curatorship, we have extremely insufficient. In Japanese, 能力が著しく不十分。And Maho, in cases of guardianship, I just need the phrase which is used. So it's the article which says in Japanese, 各状況. I remember the Japanese wording, but I don't remember the English one. It's around 7 or maybe, yes, 7, 8. The English title is Commencement, Ruling of Commencement of Guardianship. And it should be around 4, 5, no, sorry, 6, 7, 8. Of civil code, of course. Okay, so when you find it, you raise your hand, okay? So, as you can understand, there is a difference of the level of the incapacity and of the insufficiency. A question I receive from students is, how do we know to which category a person belongs? Answer, we don't. The judge decides. Okay, so you go to the court and you ask for adult guardianship. Maybe the judge will say, no, it's not a situation for adult guardianship. Let's go to curatorship. Question, what is different between guardianship and these two things, Hosa and Hojo, curatorship and assistance? Please remember, so how is it going, Maho? No? Okay, are you using the site of the Ministry of Justice? No? Yes, yes. So what's the wording after that? Oh, could you pass the microphone to her, please? Yes.
With respect to any person who constantly lacks the capacity.
Okay, yes. So it's constantly lacks the capacity. Which article is that? Is it 7, as I said? Or yes. So it's Article 7. You can check it afterwards. In Japanese, Maho, it's kaku joukyo, isn't it? Kaku from lack, kisseki, it's kaku joukyo. Okay? So in Japanese, it's kaku joukyo. Joukyo with tsune. Tsune and joukyo kyo. So it's not the other joukyo. It's tsune and kyo. You can check it later. It's Article 7. And in English, once more, Maho, it is constantly
lacks the capacity to discern.
Excellent. So now you can see the difference between the, Now you can see the difference between, here. So please be careful. Constantly for adult guardianship, extremely insufficient for curatorship, and insufficient for assistance. Now, as I told you, here you can rescind everything except for daily purchases, and you have the right to represent and administer the property. So, oh, and Maho, congratulations, you reached the maximum for today. Thank you for helping. So, this is very heavy. You have all the rights. Represent, administer property, and rescind. How about this? Please be careful. This is very good for the final exams too, because it's a bit complicated. In cases of curatorship and assistant, it's a right to consent, so it's different from the guardianship. It's the same as with minors. A right to rescind if there was no consent, and a right to represent. So, in cases of Hosa and Hojo, curatorship and assistance, the person needs to ask for consent. If he or she receives a consent, there is no problem. If there is no consent, please be careful. They can rescind. So it's the same again. If the thing that was done without consent was good, you don't care. You don't rescind. So, this is something you can use. A mistake students usually make during the final exams is that, so the guardian is the Kokenin, the curator is the same name Kokenin, guardian of an adult, okay, not of a minor. The curator is Hosanin and the assistant is the Hojonin. The most important thing is the right to consent. The guardian of an adult does not have that right because he or she can rescind all acts. Oh yeah, you can take photos if you want to, it's okay. Yeah, that was good, just like it. Thank you. Don't take photos of me, okay? Only the slides. Yeah, no, it's okay. So, please be careful because the guardian of an adult does not have the right to consent. It's only a right to rescind in all cases. The curator has the right to consent in some important cases, we don't care about details, and the assistant only in some cases. Now, right to rescind. Yes, it's the strongest right of a guardian. He can rescind all acts except for the daily purchases. The curator, yes, but only for some important acts and only if there was no consent. Please be careful. You need to combine it with the consent issue. So it's not that the curator can say, I will rescind that. No. If he has given the consent, then he cannot. And the assistant, again, yes, he can rescind only for some acts. Again, only if he has not given consent. And the right to represent, well, you don't have to worry so much about that. Now, another issue is, who is the guardian? Is it a superhero like in the Disney movies who can fly, etc.? The answer is no. Is it a relative? The answer is no. Which is surprising, because you would think that a guardian or a curator or an assistant would be a relative. The answer is no. Nowadays, in most cases, they are not relatives. So who is the guardian? It's another person or a company. There are also companies. In most cases, it is lawyers. So, I have many friends who are young lawyers. They have their own office. They work alone. I ask them, what kind of cases are you doing? And they answer me, I'm doing a lot of guardianship. I'm a guardian of a lot of adults. And they're living from that. Why? Because being a guardian, as you can see, you have important rights, which sometimes are difficult to understand. You can go to a bank and withdraw money from that person's bank account. But you need to show some evidence, some paper, you need to write some things. So people feel that no, it's too difficult for us. Let's leave it to a lawyer. There was a case where a person who was 75 years old had a guardian who was 85 years old. The guardian was older than the person because the guardian was a famous university law professor. So it was really funny. He was talking to us about that. He was saying, I'm 85, but I'm a guardian of a guy who's 75 because I'm a law specialist, etc. So you can see that it's a market also for lawyers. So the question is, and we are going to finish with this slide, we are going to talk about the voluntary issue next week. Do lawyers always do their job properly? And the answer is actually no. Why? Well, because if that person has a lot of money in the bank account, and you have the power to withdraw it legally because you're the guardian, you might withdraw a bit more than necessary and use it for your girlfriend, maybe, etc. And there have been such cases. So the issue is the duty of care. We mean, what's the level of care required when you actually do your job? It's the care of a good manager. In Japanese, zeimyou na kanrisha no chui. What's that? They don't care about your personal abilities. So it doesn't mean that if you are a young lawyer, for example, you can make more mistakes. But if you are an experienced lawyer, you can make less mistakes. No. They look at an average good manager, so it doesn't depend so much on your personal abilities. You need to take good care. And you also need to respect the intention and personal considerations of the adult worlds. I know that it's a bit complicated and difficult, but we are going to start with a small revision next week. And of course, if you have questions, you can send me emails or you can ask me right now. So, see you next week. Have a good week. Bye.